Good afternoon. It is a great privilege for me as Vice Dean of the Faculty of Law to welcome you all to this new series of lectures on the global citizen, which is offered at the University of Oslo this term. As you may know, 2012 is set out to be the year of internationalization at the University of Oslo, where among other things, the faculties have been challenged to develop open lectures on the topic of the global citizen. The aim of these lectures is to raise awareness, ask fundamental questions, and discuss the relations between knowledge and global responsibility. As we have seen too often, a vivid and healthy democracy is not only built upon education and knowledge, it is dependent on human beings with insight, capable of using their knowledge to create a better world. The link between responsibility and global awareness, solidarity and academic freedom will be discussed through 8 key lectures offered this term, and we hope to see you all at the coming lectures as well. Please allow me to introduce to you today's lecturer, Fredrik Sejersted, Professor of Law and Director of the Center for European Law at the Law Faculty. In 2010 to 2011, he was head of Europautredningen, the Europe Review, a commission appointed by the government to review Norway's relation to the EU, which resulted in the report Outside and Inside. The topic of his lecture is Europeanization of Law. I now have the pleasure to give the floor to Professor Fredrik Sejersted. Thank you.
Thank you, Kirsten, and welcome to this lecture on the Europeanization of Law with the subtitle National Law and the New Federal European Legal Order. This is one lecture, but it really has 2 organizers. It was planned originally, which is a long time ago now, as part of what we call International Days here at the Faculty of Law. And that is an event which is for the law students of this faculty in general, and in particular for the foreign students who come here under student exchange programs. So I suppose that part of the audience is composed of foreign law students coming to Oslo, and very welcome to you. I hope you will get a great time in Oslo. So that was the background for this, and it was supposed to be a small and modest lecture for some handful of international students here at the Faculty of Law. But then the main university established this lecture series on the concept of global citizen, and they asked that this lecture was incorporated into that lecture series. And I was a bit surprised by that, and I was a bit hesitant to say yes to that, because it does raise the question, whatever does the concept or the theme of the Europeanization of law has to do with global citizenship? And the answer, I'm afraid to say, is not a lot. Not all that much, but it might still fit in. The concept of citizenship can have different meanings. It can mean one thing to a historian, a political scientist, anthropologist, and other academic disciplines. But to the lawyer and for the Faculty of Law, citizenship is a legal concept, and it's a national concept. It's defined by law, and it is usually related to a state or even a nation state. And it is a concept from a legal point of view, which is a combination really of a set of rights and obligations, a bundle of rights and obligations, which the citizen has as a member, as a citizen of that state. This is usually symbolized by a passport, and it gives a number of rights. It gives rights of political participation, social, economic rights, etc. And it also brings with it a number of obligations. Obligations to pay taxes, obligations perhaps to do national service in Norway, and etc. And in a modern society like Norway, this legal concept of citizen is a really large bundle of rights and obligations. The concept of a global citizen, global citizenship, is something else. This is not a legal concept. This is, the way I understand it, it's a moral concept, it's a political concept. It is used perhaps often as a political term or even a political slogan or catchword in order to be an instrument in worthy causes like fighting inequality and international poverty, in fighting for environmental issues, immigration, and etc. Promotion of human rights, etc. But it's not a legal concept. There's no such thing from a legal point of view as a global citizen. There's no citizenship of the world which gives us legal rights and obligations. Even if international law has been growing, there are increased international human rights which are being recognized. There are increased treaties on a number of issues, but this does not add up to a bundle of rights and obligations for the individual. So from the Faculty of Law, it's very difficult to contribute to a series on global citizenship. But there is, however, a transnational citizenship also in the legal sense. This, however, is not at the European level, not at the global one. It's not at the global level, it is at the European level. And at the European level, it's possible to talk about a citizenship even in the legal sense. We know this concept from the European Union. They established the concept of European citizen already in 1992 in the Maastricht Treaty. And for the last 20 years, they have been working hard to fill up this concept with actual legal rights and obligations. And this today includes a number of, especially rights of free movement, rights of settlement, right of employment, political rights, and a number of other economic and social rights. This is even symbolized in the European Union by a common passport design. The passports of European citizens from the EU member states have the same design. And on closer look, if you look at this European citizenship, it is not something that is confined only to the 27 member states of the European Union. First, EU law and the rights and obligations in EU law has been taken up not only by the EU member states, but increasingly also by most other European states. Definitely Norway, through the EEA agreement, the Schengen agreement, and numerous other agreements. And we see this with other European third countries, that they are, if not formally, then at least in effect, they are part of this, to a greater or smaller extent, part of this European citizenship of the EU. And then second, there are other European sources, other European treaties and obligations. And the most important of these, which I will focus on, is the European Convention on Human Rights, which is given by the Council of Europe and which has been incorporated by all the 47 member states of the Council of Europe. And together, these two, and that is the theme today, EU law and the European Convention on Human Rights and other European obligations, together these form a bundle of rights and obligations which makes it possible to talk in a broad sense about European citizenship. This is also perhaps a bit of a corrective or a supplement to the Global Citizen Lecture series. And it's not necessarily a bad thing that today we focus on the European level, because there is a tendency, I would say a regrettable tendency, which has been recently documented, that Norwegian academics tend to forget the European level. There was an article written not long ago by Katrine Holst and Jon Erik Fossum, who analyzed to what extent Norwegian academics relate to Europe. And their answer was, and their finding was, that Norwegian academics are very Norwegian. They look at Norway. And when they do go international, they jump right up to the global level, and they talk about global issues. And they tend to forget that in between these two, there is the European level. There are many reasons for that. One is that we are outside the EU and we do not really know that we are part of the European level, or we try not to talk too much about it, or we try to forget it because it's so politically controversial in Norway still. I'll come back to that. But anyway, they tend to forget this European level, even though when we talk about international cooperation, it is the European level where most of the action actually takes place, at least very much so for the legal discipline, legal academics. So to those of you who have come to hear a lecture on global citizenship, I will say sorry. You're not going to hear much about that, but you will hear about European citizenship. And the theme are the Europeanization of law. And the main point, which is very easy and very short, is that during the last 20 years, from the beginnings of the 1990s until today, the European legal situation has been transformed, more than most of us are aware of. And today, at least in Norway, and today we are living, for all practical purposes, in a federal European legal order. And this raises a number of new challenges and problems and questions that we have to know about. There was a very famous English judge who was called, his name was Lord Denning. And as far back as in 1974, he gave a judgment, and he had a very fluent style of writing. And he wrote in 1974, which was only 2 years after the UK had joined the European community, he wrote in this judgment, a very famous quote, that community law, or the Treaty of Rome, was, and I quote, "It is like an incoming tide. It flows into the estuaries and up the rivers. It cannot be held back." This was in 1974. And in 1990, he gave another lecture, and then he went much further, and he said that, quote, "No longer is European law an incoming tide flowing up the estuaries of England. It is now like a tidal wave, bringing down our sea walls and flowing inland over our fields and houses." So this was in 1990, and he was ahead of his time. For this trend, this flow, this tidal wave, has continued to grow for the last 20 years into something, if we use his metaphor, into something of a tsunami. And today, I would say most of national law and politics is flooded with European law of one sort or another. And this European law claims supremacy before national law, and it regulates national affairs from the broadest principle down to the tiniest details. This relationship between national law and transnational or international law, this is not something new. This has developed back and forth over the centuries. The idea that law should not be confined to the local community or the nation, this is very old, and to many it's natural. If you go back to Roman times, there was Roman law, and there was Roman citizenship, and this was in the whole of the Roman Empire. Later on, there was church law, canonic law, and in a sense, there was a citizenship in the medieval ages of the Catholic Church. But then came the rise of the modern nation state in the last couple of hundred years. And with the nation state came national law. And the borders of the state became the borders of the law. There's one law on one side of the border, and there's a completely different law on the other side of the border. Some advantages to that, especially if you want to run away from the law, you can just cross the border. But still, it's, at least to non-lawyers, it's a bit of a strange concept that what is right and wrong should be defined by the borders of the state. But it has been so for many centuries, and it still is like that to a great extent. We still have strong national legal systems in all the European countries, with national differences, national characteristics. But the new thing is that on top of this, we now have a new layer of transnational law, which is quite new if you look at it in a historic perspective. And this has been growing and developing very rapidly for the last 20 years. One part of it is truly global law or universal law, legal rules which are recognized by at least most states of the world. International law, as we know it, has been growing fast in recent years, and it has been expanding into new areas like not just traditional international law, but you find international law now in international environmental law, international criminal law, and a number of other areas which used to be just for the sovereignty of the nation state. But still, even today, and even with all these international treaties and legal globalization, this is still a very thin layer if you look at it from a legal perspective. And it's kind of old-fashioned international law. It is primarily binding on the states. It's a very small, it's a very thin layer compared to the really large expansion of transnational law, which is at the European level. The Europeanization of law is something which is vastly more extensive than ordinary international law, and it is also very different in character. It's not ordinary international law. It is what we talk about in the European sense as supranational law, meaning that these international rules are not only binding on the state, but they give direct rights, sometimes obligations, but mostly rights, to the individual citizen and companies in the individual member states. They have direct effect. They can be invoked directly by the individual and the companies before the national courts, and they claim supremacy over national law in case of conflict. And they are monitored and controlled by supranational international organizations and institutions. In the EU, by the Commission and the European Court of Justice in Luxembourg, and under the European Convention on Human Rights by the European Court on Human Rights in Strasbourg. The two main parts of this Europeanization of law, as I've said, is EU law and the European Convention on Human Rights, or I would simply call it the ECHR, or the Convention. And when I talk about Europeanization of law, it is, for most practical purposes, the combined effect of these two legal regimes that I refer to. And by Europeanization, I mean that issues and questions that were formally regulated and decided at the national level by national political procedures and national law, these are now determined and regulated at the common European level, and regulated often in quite detail by common European rules. EU law and the European Convention, these are not new legal regimes. Both of them date back to the early 1950s. The European Convention was first written in 1950, and it was ratified in 1953. And EU law, as you probably know, was first created in the 1950s, in 1953, and then with the Treaty of Rome in 1957. So the seeds to this Europeanization, they were sown a long time ago. But both of these systems had modest growth for the first 30 or 40 years. And it was only from the early 1990s, the last 20 years or so, that both of these systems have expanded radically along several lines, both widening and deepening the reach of these legal regimes. So that today the number of issues which are regulated at the European level is vastly greater than it was 30, 40 years ago, and the number of European states that participate in these legal regimes is also vastly larger, and the European institutions are greatly more powerful than they were. And this is something that has happened, for most practical purposes, over the course of the last 20 years. EU law and the European Convention on Human Rights are two very different legal systems. They are different in content, they are different in functions, they have different membership, different dynamics, and etc. But there are also striking similarities and connections between the two. And they have developed more or less in parallel over the same period of time in the same part of the world. And for the purpose of understanding this broader trend in a great perspective, it is necessary and useful and constructive to see them as two parts of the same broader trend towards the Europeanization of law. And my argument, which is debatable, is that together these two developments, they form a fundamental shift of paradigm, or even a quiet revolution in the way we think about the law. Europe is not a political federation, even if there are people in the EU who dream about this, but it's not a political federation today, and perhaps it will never be. But it has created a legal system which has very clear federal characteristics. There is still national law, but on top of this, there is this thick layer of European law, which is federal in character, in the sense that it claims supremacy, it can be invoked directly by the citizens, and it sets limits to what the national political systems and parliaments can decide by themselves. And this has been a one-way process for the last 20 years or more. There has not been any major setbacks, and even the crisis today in EU, the political, economic, financial crisis, has not so far been a setback in this. Quite the opposite. The Europeanization of law is still very much a process which is going one way towards ever greater Europeanization. In a sense, national law has gone from being two-dimensional to three-dimensional. There's always now the third, an extra dimension. You have to look at it also from a European perspective. To lawyers and citizens who come from federal states like the United States or Germany, this is something they are used to. They are used to thinking about the law on different levels, the state law and the federal law. But for those of us coming, like Norway, coming from national legal systems, this is a very new way of thinking about the law. All these questions that the federal lawyers are used to, division of competences between the two levels, the tension between these two, should this issue be decided at the national level, the state level, or at the federal level? These are for us, new questions, new legal ways of thinking. There has been some national resistance along the way to this Europeanization of law. But compared to the enormous extent of what has really been happening, it has been a very smooth process. Very little criticism, very little political conflict. In that sense, it has been a quiet revolution. And the implications of these revolutions are only now beginning to be understood by lawyers and politicians in the European countries. To many, this creation of new European law, we could make a Latin term for it, jus Europeanum, is a wonderful thing. Finally, law is no longer confined by boundaries. There's the same law for all of us. This is necessary because we have new transnational challenges of economic trade, of prosperity, of the environmental issues and problems, criminal law, and etc. So there are numerous positive sides to this Europeanization of law. And for many of us, it is a necessary reaction to growing internationalization and globalization, and it's a necessary bulwark, a necessary defense against nationalism. But there are also problems and challenges. And one of these challenges, and perhaps the most important one from the point of principle, is that Europeanization of law also means Uridification, or as we say in Norwegian, rettsliggjøring. Because the European rules are given as law. And it means that issues that were formally decided at the national level by the national parliaments and governments and authorities through national democratic procedures, these are now regulated at the European level as legal issues. And they are taken out of the political and democratic sphere, and they are transformed into legal questions. And the power is taken from the national parliaments and governments, and they are given to the courts. And issues of great importance to society are no longer determined by political debate and votes and debates in parliament, but they are decided in courts. They are argued by the lawyers, and they are finally decided by the judges. And these judges, they sit in these faraway places in Luxembourg and Strasbourg, and places that most of us have never been and almost never heard about. And they're hidden away somewhere on the continent. But these are the new power centers. Strasbourg for the European Convention on Human Rights, and Luxembourg for EU law. For national politicians, it is increasingly difficult to understand now what is really regulated at the European level and what is left for them to decide for themselves. And the basic challenge here is within this framework, because we have taken this framework, it is already here, but within this framework, the challenge is to understand this and to understand what is decided at which level and to find a sensible balance between what should be regulated at the European level and what is still left for national law and policy. And this I will come back to a bit later. I will now talk a little bit about, first on EU law and the dynamics and development of that, and then the European Convention, and then I will look at the two together and look again a bit more into the problems of juridification and finding this balance. The expansion of EU law throughout Europe in recent decades. As I said, it started in the 1950s, and there were important developments in the 1950s, the 1960s, 70s, etc. But the great breakthrough for European law, not all EU law, not just as community law regulating trade and commerce in goods and services, but the great breakthrough for EU law as a broader legal system, that came in the early 1990s. It started with the Single European Act in 1987, and then it really had its breakthrough in 1992, with the completion of the so-called internal market and the adoption of the Maastricht Treaty, which changed the European community into the European Union. And since then, during the course of the last 20 years, there's been numerous new treaties, the Treaty of Nice, of Amsterdam, of Lisbon recently, and there has been a great expansion in EU competences. And it has for a long time now gone from just being a commercial community, trading in goods and services and so on, into being a broad political union and with a legal regime that regulates almost every aspect of national law, including so-called justice and home affairs, which is police, cooperation, immigration, border control, and all these issues which used to be really at the core of national sovereignty, and also new areas like climate law, environmental law, even areas of foreign and security policy, which are now regulated at the European level. Today, I would say there is no area of national law which is not to some extent, greater or smaller extent, influenced by European law. Be that national constitutional law, national administrative law, national economic law, national social law, national company law, patent right, transportation law, immigration law, energy law, police law, and etc., and etc. Even criminal law and procedural law are to some extent, if not so much, influenced by EU law. And the recent crisis, as I said, in the EU has not stopped this. On the contrary, I think, at least in Norway, people think that because there's a crisis in the EU now, the integration process is slowing down. But this is not so. Even the financial crisis has not led to a slowing down, but it has led to increased competences being given to the European level on the financial markets and economic legislation. And if you look at the areas outside of the euro crisis, the internal market, justice and home affairs, security and foreign policy, the environment, energy law, we see that the legislative activities in Brussels are going as fast as ever. They have rather speeded up than slowed down. For EU law, there's also the requirement that all rules of EU law, they have to be incorporated into national law. So unlike ordinary international law, which are treaties binding on the states, these rules are actually implemented into national law. They are, as the English say, they form part of the law of the land. And they can be invoked directly by the citizens before the national courts, against the national authorities, and if necessary, also brought before the Court of Justice in Luxembourg. There's been different estimates in various EU member states on how much of national law is today influenced by the European level. And this is very difficult to measure in a scientific, academic ways because national legal systems are so different. But if you look at the average and if you look at the better studies, I think you will find that around 20% of national legislation is to some extent directly European rules, EU rules, which have been taken into national law. And then, of course, there's the requirement, in addition, that even for the 80% that remain national law, there is the requirement that this cannot go against EU law. EU law is on a higher level, so if there's conflict between EU law and the ordinary national rules, then EU law takes supremacy. So in that sense, the whole of the national legal system is subjected to EU law. This is a bit on the deepening of the EU integration legal process. And then there's the widening. And here we really see the enormous developments over the years. From the original 6 member states of the EU, European Community in the 1950s, to 27 European Union member states today, and soon to be 28 when Croatia becomes a member. And the great breakthrough here was in 2004, of course, with the inclusion of Eastern and Central Europe, 10 states, and then 2 more a couple of years later, into the EU, which transformed the European Union from a kind of Western European rich country club to an all-European broad political union with great differences between the member states. Still only 27 member states to the EU. There are 47 member states to the Council of Europe. But if you look at these last 20 states that are European but not part of the EU, which states are those? Well, there are a couple of very rich Western European states, Norway, Switzerland, Iceland. And then there are the microstates. And the microstates really make up a large part of the number, like Monaco, Andorra, San Marino, Liechtenstein, and not Luxembourg, of course, Liechtenstein. And then there are the states that are really in the east, like Belarus and the Ukraine and Russia and Turkey. And then there are states in like the Caucasian states, Georgia, Armenia, Azerbaijan, which are members of the Council of Europe, but not of the European Union. So it's rather marginal. And the interesting thing about EU law is that it is not simply confined to the EU member states. We see this very clearly in Norway. Norway, Iceland, and Liechtenstein, as part of the EEA agreement, has taken most of EU law. The same goes for Switzerland. The Swiss have approximately 200 agreements with the EU, and they have taken most of EU law. The same goes for the microstate, and the same even goes for those, to some extent at least, for many of those third countries in Eastern Europe that are adapting to EU law, and they are taking EU law even if they're not members of the European Union. So EU law is really much wider than the EU itself. And this is something we see very, very clearly in Norway. It was mentioned that I was head of a government-appointed review committee, which we established a couple of years ago, and we gave a report in January. And it's this report in Norwegian, utenfor and innenfor, outside and inside Norway's agreements with the European Union. And it's 911 pages long. And this is not because we are writing a lot about it is not because we are using so many words. It is because we needed 911 pages to really set out the extent of the Europeanization of Norway for the last 20 years. And this Europeanization is, for the most part, a legal Europeanization. It's a political agreement, but it comes through political rules. Our estimate is that Norway has taken approximately 3/4 of EU law and policy and incorporated it into the Norwegian legal system. This is for those of you coming from other countries or not being lawyers, this is the holy book to the Norwegian lawyer. This is the Book of Statutes, Norwegian Book of Statutes. It contains approximately 600 statutes, that's all of them, and it looks like a national book. But the whole of this book is filled with European law. Approximately 1/3 of these statutes, approximately 170 out of 600 of these statutes, contain, to a greater or smaller extent, EU rules through the agreement, the Schengen Agreement, and so on. There's an illustration at the back of the handout of how this looks, but of course there should have been 170 blue and yellow stickers into it, not 20 or 30 or something, which you will find in the picture. The Norwegian case really illustrates that this Europeanization of law, this European integration, is like a force of gravity. Even if a state like Norway is not member of the EU, it is impossible as a modern European state, an open state, it's impossible to stay out of the European integration processes, even if we wanted to. And in effect, we do not want to. In Norway, we have this strange situation that as long as we do not talk about EU membership, which is very controversial in Norway, but as long as we do not talk about it, we can incorporate almost any European rule, and we do so. And most of these decisions are taken unanimously by the Norwegian Parliament, and only a small handful are controversial. So we are adopting EU law, and we are probably doing so more efficiently and effectively than most European member states. And it shows that this is like a force of gravity. Europe is integrating, economically, technologically, in a number of areas, and legally. And it's impossible for one country to stay outside of this. It's like a force of gravity. You can see Brussels as the center, the sun, or the black hole, if you prefer that. Depends on how you look at the EU. And the European member states and the other European states, they are circling around Brussels. And the circle that Norway is in is not very far from those EU member states, which are not members of everything. We are approximately in the same circle around Brussels as the UK, for example. The Swiss have the same experience. So this is the development. There's a lot to be said about that. But this is how European law, especially during the last 20 years, has developed into a new federal legal order. And that's just the EU. And then we have the European Convention on Human Rights, which is the second main pillar. The evolution of the European Convention on Human Rights, that can be seen as part of a broader internationalization of human rights and basic rights. There's a large number of international treaties on basic rights, United Nations treaties, other treaties, different aspects of international human rights. But for the people of Europe, the citizens of Europe, by far the most important is the European Convention, because it's more detailed and because it is incorporated into national law much more than the other international treaties, and because it's supervised by the court in Strasbourg. It's a lot more supranational in character than other international human rights treaties. As I said, the European Convention on Human Rights, it was made in the 1950s, ratified in 1953, so it's been there for a long time. But again, it has developed over the course of the last 20 years, at least in 4 different ways. First, there are new protocols to the treaty. Altogether today, there are 14 protocols to the European Convention, which makes it more extensive than it originally was. Second, the Convention, and more important, the Convention has been developed by very dynamic, very activist interpretation by the European Court on Human Rights in Strasbourg, which has transformed this convention into something completely different than most of the member states thought they signed up to in the 1950s. And third, the convention is being gradually more often invoked at the national level against the national authorities before the national courts. And this took a long time coming in most European states, definitely in Norway. Even if we had the convention since the 1950s, it was only in the very late 1980s or even the early 1990s that people in Norway, the citizens of Norway, actually started to, and their lawyers, started to invoke the European Convention before the Norwegian courts. And then it completely took off, as I will return to in a minute. And then there's the fourth dynamic, which is, again, the widening, the geographical widening of the European Convention on Human Rights. It started with 10 states in 1953, and today all the 47 member states of the Council of Europe have signed the agreement, and they have given their citizens the right to enforce it directly before the national courts, and if need be, to appeal the cases afterwards to Strasbourg. And again, it is in the course of the last 20 years, with the fall of the Iron Curtain and the democratization of Eastern and Central Europe, then again that the convention has become a common bill of rights for all the citizens of Europe. So these 4 developments together, new protocols, dynamic interpretation, increased use of the convention before the national courts, and the geographical expansion, today this makes this European Convention a common bill of rights for all the citizens of Europe. It's a very detailed Bill of Rights because the court in Strasbourg has interpreted it down to a very detailed level. So again, it's everything from the broadest principles to the tiniest questions, which can be seen as questions of human rights under the Convention. The Convention can be invoked, as I said, before the national courts, and then it can be brought before the Court of Human Rights in Strasbourg. And the extent of this, which again has come in the course of the last 20 years, is illustrated by the fact that the European Court, the Court of Human Rights in Strasbourg, today has 150,000 pending cases. It has become the victim of its own success. The European citizens are invoking this convention so often that the court is completely overloaded and is actually in a time of crisis at the moment. But it's a crisis which is the result of its own success. 150,000 pending cases. If you look at the role of this convention in Norway, it is very big. And this is partly due to the fact that if we look at the Norwegian constitution, then the Bill of Rights, the catalogue of human rights in the Norwegian national constitution is very short and lacking in a number of respects. So for Norway, because we do not really have proper constitutional protection of human rights in the national constitution, then the European Convention has become ever more important. And it is being invoked in Norway more often than in most other countries because we do not have a proper national Bill of Rights. We are discussing at the moment, as a constitutional reform, constitutional amendment, to introduce in Norway a national catalogue of human rights in the Constitution. If we do so, that will be a couple of years from now, in 2014. The proposal has been made, and the idea is that in 2014, when the Norwegian Constitution is 200 years old, there will be a big anniversary, probably in this room also, and then we should put a proper Bill of Rights into the national Norwegian Constitution. And it's a very detailed proposal which has been drawn up by a committee, and if you look at that proposal, it is to a great extent influenced by the European Convention on Human Rights. So again, we see this Europeanization. And even if we get our national Bill of Rights, it will be not copied, but it will be heavily influenced by the European Convention on Human Rights. As I said, the breakthrough in national courts in Norway of the Convention came in the early 1990s. And if you do a quick search of the database of just the Supreme Court, not to talk about the city courts and the courts of appeal, but just the Norwegian Supreme Court, you will find that the European Convention has been invoked before the Supreme Court of Norway in more than 1,000 cases over the years. And that is a very substantial part of the caseload of the Norwegian Supreme Court. And in addition, Norway has been, I should say, drawn before the Court on Human Rights in Strasbourg in a number of cases. In different cases, cases of criminal procedure, cases of freedom of expression, cases of religious belief, and other cases. Not quite so often as the Italian authorities or the Turkish authorities, or not to say the Russian authorities, but even for Norway, small modern state usually takes pride in complying with basic rights. Even Norway is being drawn before the court in Strasbourg on numerous occasions with allegations of violation of the European Convention on Human Rights. And there's been a lot of cases which the Norwegian government has lost. And the court has come to the conclusion that Norway is in infringement of the European Convention. The most controversial of these cases came this summer, in June 2012, and that concerned private property rights. I will not go into the details, but we have a very complicated system in Norway for what we call ground lease rent, tomtefeste in Norwegian, which regulates people can lease property and build houses on it, and it's very regulated how the fees, the rent for this ground lease should be determined. And it's not a free market. There are government rules which has been made by Parliament. And these are, of course, this applies to hundreds of thousands of properties in Norway. So it's a very big issue from a political point of view, social point of view, economic point of view. And this latest regulation on this, which was made by the Norwegian Parliament, after painstakingly arguing this for a number of years, they finally reached a majority a couple of years ago on how they should regulate this ground lease rent. And it was, they made the law, the Norwegian law, and it was challenged before the courts on the basis that it was both against the Norwegian Constitution, but also against the European Convention on Human Rights. And the Norwegian Supreme Court, they found that this statute, this Bill of Parliament, was completely in accordance with the European Convention on Human Rights. There was no infringement. But then the case was appealed to the court in Strasbourg, and they decided that it was not. That this Norwegian statute was against the protection of property in the first article of the European Convention on Human Rights. And the reason why this is so controversial is that this is for the first time the Convention is really going into something that is not just individual rights of freedom of expression or religious belief or something, but into deep and big issues of social and economic policy, affecting tens of thousands, if not hundreds of thousands, of Norwegian citizens. And this judgment has led to quite severe political debate and to some extent criticism of the European Convention. And it will be very interesting to see in the time to come whether this will influence the Norwegian view of the Convention as such. So this is a bit on the dynamics and development of the European Convention. This in itself, this could be a 2-hour lectures. But as you will have seen, the EU law and the conventions are two different legal systems. The EU law is very much wider in scope. It's a bit more supranational, and there are different functions and origins of these two legal regimes. But there are a number of similarities and connections. First, of course, all the 27 EU member states are part of the European Convention on Human Rights. And the EU itself now is a party to the convention and in the process of adapting to that. Second, EU law has also its own catalogue of fundamental rights in EU law, but that is in effect, for most practical purposes, coordinated with the convention. And the convention is the most important instrument when it comes to human rights, both within the convention legal system and also in the EU legal system. Third, both these legal regimes, EU law and the convention, are federal in character, as I was talking about. They form a European level which is above national law, and they can be used to control and to review national law. And national law will have to be set aside if they are in conflict with either EU law or the European Convention. And both are interpreted and developed by these very strong, very activist supranational courts in Strasbourg and Luxembourg. There is also similarities, and this I will return to in a minute, between the basic legal technique which is used in EU law and under the Convention for establishing the balance of competences between the supranational European level and the national level. So together these two, they supplement each other. The Convention gives the common Bill of Rights for all the citizens of Europe, and EU law supplements this with more fundamental rights, but also with what is often referred to in the EU as an economic constitution. Not a political constitution, but an economic constitution, laying down the common basic principles for economic activity. Freedom to trade goods and services, freedom for persons to move, freedom of capital, freedom of movement, as well as a number of detailed rules in EU law. Now, as I said, Europeanization is also rettsliggjøring in Norwegian, is Uridification. And this has been a debate in Norway for a number of years now. This concept, Uridification in English, is not good, but in Norwegian we call it rettsliggjøring. We could try to translate it as legalization, but that would be something else. So, Juridification. Juridification means that issues that were formally decided in politics through democratic procedures are now regulated by law and left to the lawyers. Meaning that rights are given to the individual, citizens, companies, which they can invoke before the courts against the national authorities and against the national parliaments. Juridification is something that can take place at the national level. If we take an area, for example, welfare rights, which 20 years ago was, you didn't really have welfare rights. You could get your welfare check, but if they did not give it to you, you did not really have much of legal rights to stand up and go to court. But this has been transformed. Welfare right has become a legal system. You can claim you are entitled legally, and if you do not get your welfare check, then you can go to the courts with this. So juridification is perfectly possible at the national level. But then there is the European level, and European juridification is something else and a lot more binding. Because when something is made into European law, then it's no longer possible for the individual member states to take that away. Then the state as such and the national parliament as such is bound by the juridification. And of course this is something that the national parliaments sign up to freely, or more or less freely, but in reality often they do not have an alternative. They have to participate in the European Convention on Human Rights. They have to take this EU legislation if they want to trade goods and services and etc. And once they've done so, it's a lock-in. You can't get out, and you can't get exemptions. You can't cherry pick and say, I want to be part of that, but not part of that. You have to take the whole package. And if there's one area you do not like, you would prefer, and you, I know the national parliament or the government, prefer to stay out, you cannot do that. You are locked in at the European level. This Europeanization, of course, it means a transfer of power to the courts, both to the national courts and to the supranational courts. And it means a much bigger role for what is sometimes referred to as judicial politics. Much bigger role for judicial politics than what we are, at least in Norway or the Scandinavian countries, than what we are used to. We are not used to judges playing a political role. like they are in the United States, for example, or in some other countries. But through this Europeanization, even our national judges have got a far greater political role than they used to. And this is, again, this is unusual to us, seeing judges behave and have that function. The transfer of power to the supranational courts, I've talked about it. These courts are situated in Luxembourg, Strasbourg, these burg places in the middle of the continent, very far away from Norway. And for a number of years, they lived a very sheltered existence. Very few people, at least except a few lawyers, were aware of these courts somewhere down at the continent. And it's only really in the course of the last 20 years or so that there's been more political limelight on these courts. And actually, for the first time, a more critical approach and debate on whether these courts really, what kind of function they really play. For the first 20, 30, 40 years of their existence, they lived a very sheltered life. And they developed EU law and they developed the European Convention without much criticism. This is a bit different now, but still they are living partly their own life down there somewhere at the continent. And then there's the transfer of power to the national courts, because these European rules, as I said, they can be invoked directly before the national courts. In Norway, before the ordinary national Norwegian courts. And the European law empowers the national courts to set aside national legislation if there is conflict with European law. Today, one single judge in Oslo Tingret, the city court of Norway, can set aside a statute passed unanimously by the Norwegian Parliament if he finds that this is in conflict with European Convention on Human Rights or EU law through the EEA agreement. And again, this is something new. And it's a shift in the fundamental constitutional balance of power between the judicial branch, the courts, and the legislative and executive branches. So the courts, the judicial branch, has been tremendously strengthened at the cost of the parliament and the government through Europeanization. There's been a debate on this in Norway. We had something called Maktutredningen, the power review. Actually, we had two of them. But the latest one, which came 10 years ago or something like that, it was a public government review on power structures in Norway. And one of the chapters in this report, who has the power in Norway, what does power mean, and how does it shift over time, one of the chapters was on Uridification. And this Norwegian report was very critical. And the main point was that this Uridification comes at the cost of national democratic procedures, and there's a democratic deficit, and this is bad for democracy. It's very interesting that in Denmark, they had the same kind of review, government review, a couple of years later. And they had exactly the same findings. They found that, yes, there's been extensive Uridification. Power has been taken from parliament, given to the courts, and this is good for democracy, according to the Danes, because they had a wider concept of democracy. And they saw democracy as a concept, including also the individual rights of the citizen and companies. And this is, of course, strengthened. But it is strengthened at the cost of the collective interest of the majority. So the citizen, not the global citizen perhaps, but the European citizen, is strengthened. The common majority democratic procedures are weakened. There are many, many positive sides to this. I've talked about some of them. The same law across the borders. This is necessary in order to meet transnational challenges. It's also good for the individuals. It improves legal certainty. It improves perhaps stability, predictability, protection of legal rights. It's good for the citizen. But there are these problems of the democratic deficit. And there is this problem that a lot of decisions are now taken by judges. Take the Norwegian case on tomtefeste, on ground lease rent. This is not a typical judicial question, or at least I would say it's not. It's not a question of individual rights and the court can. It's a question of broad social and economic policy. Parliament has been debating it for years and years. They find a political compromise, but then it's taken out of the political arena and it's given to the courts. And are the judicial procedures really the best decision-making procedures for deciding these kind of issues? That is the debate today. Judicial politics. What should be left to the judges and what should not? But we are leaving more and more to the judges. So, and this is the final great theme of this lecture, there is a need to find a balance. There's a need to find a balance between the European level and the national level. And how do we do it? And we have to find it within the existing legal framework. It's not an option to go out of the European Convention. It's not an option for Norway, at least not in reality, to take out EU law by taking, well, we could terminate the EA agreement, but we would still have to have 200 other agreements with the EU. It's not an option to say no to this Europeanization of law. This has come, and we are part of it. So if we want to strike the balance between the European level and the national level, then we have to do it within the legal system. And then, for those of us who are lawyers, and I suppose that's most of us, then we have to know the legal instruments for determining the balance between what should be decided and regulated at the European level and what should be left at the national level. In EU law, there are 3 legal instruments for determining the balance. You will find them in the handout. The first is that you have to have rules on division of competences. The second is the so-called principle of subsidiarity, and the third is the principle of proportionality. The first 2 I will just mention briefly. Division of competences. This was not so clear in EU law before, and you don't find anything like that in the European Convention on Human Rights. But in the Lisbon Treaty, because of increased calls from the European states for clearer division of competences between EU and national law, they put in articles providing catalogues of which competences are given to the EU and which competences are still at the national level. You will find it in the Treaty on the European Union and the Treaty on the Functioning of the European Union. Both these basic treaties have articles on division of competences. The problem is that it's easy with the competences that are given exclusively to the EU. And it's easy with the competences that are still exclusively at the national level. But then there's a big area in between, which is called shared competences. And that is where most of the action takes place. Shared competences means that the EU can have competence. National parliaments and governments, they have competence, but only so long as the EU has not made legislation and policy in that area. So even if they now have provisions for this in the treaties, it is still a very, very, very complicated issue. In the United Kingdom, they have a big EU debate coming up. It has been raging for some time now. And this summer, the British government, because they are a coalition government between the Tories, who are Eurosceptics, at least some of them, and the Lib Dems, who are very keen on Europe, they started a big government review on the division of competences between EU and the UK. And they've even been in Norway and talked to us because they saw our report, which was kind of nice, that somebody came from England to look at our report. And they are doing some of the same exercise, but with more emphasis on what is the exact division of competence. What have you really given away to Brussels? And what should we try to take back? So this is a very difficult issue in the EU. Then there is the principle of subsidiarity. And this was introduced in EU law in 1992 in the Maastricht Treaty. And it states, it's in the treaty, and it states that the European Union shall only take action if and so far as the objectives of the proposed action cannot be sufficiently achieved by the member states, but can rather, by reasons of scale or effect of the proposed action, be better achieved at the Union level. So they should only take action in the EU at the European level when that is the best level to do it, not the national. But this is not really, this has never been, legally speaking, an operational principle. It's a political principle. It can be invoked in political procedures, but it's very difficult to come afterwards and say that this and this legal act is against the principle of subsidiarity. Then there is the principle of proportionality. And from a legal point of view, that is the most important principle. That is a legal concept. That is a key concept for lawyers for understanding the balance between the European and the national level. And this is, I would argue, in most controversial cases, the principle that really determines the exact borderline between European law and national law. And this I will talk to under the heading, the subtitle, point 6 of the handout, National Room for Maneuver under Margins of Appreciation. Basically, EU law and the European Convention on Human Rights have the same regulatory model or technique for determining this exact borderline between European and national law. And the model is very easy from a legal point of view. 1, general rule, 2, exemption. First, both under the Convention and the basic EU law, especially the 4 freedoms, free movement of persons, capital, goods and services. First, there is a broad general European rule, stating the common European principle that all national authorities must respect. And second, there is the possibility of exemption, that national measures can still be allowed, even if they infringe the main rule, as long as certain criteria are fulfilled. And this is the same model both under European Convention and EU law. And it's a model which gives the European level very broad range, because the first rules, the broad rules, are almost always interpreted as broadly as possible. So everything is under European law. But then you have a possibility of exemption of national measures, but only if you can justify them. That's the model. It's a very European model. You have to justify national measures, because most national measures that to some extent can be an infringement of the convention or a restriction on the free movement or indirectly discriminate and so on, they are under European law, and as a national parliament or government, you have to justify why you can still do that. Under the convention, the first question is whether a national measure is an infringement of a given article. For example, if a national measure is in principle an infringement of the freedom of expression or the protection of privacy or the protection of religious belief. And this is interpreted very broadly so that numerous national measures can in principle be infringements. But then there's always a second paragraph, almost always, not on torture. There's no second paragraph on torture. You cannot torture. But on most of the other human rights, there's a second paragraph saying that you can infringe this, freedom of expression, protection of privacy, etc., if the national measure is justified by reference to legitimate national concerns and if it's proportionate, in the sense that it is necessary in a democratic society. And you find the same in EU law, at least under the 4 freedoms. The first question is whether this national measure, this national regulation, is an infringement or a restriction on the free movement. And again, this is interpreted very widely. And then, if it is a restriction, then the second question is it still allowed? And it is allowed if it is, 1, justified by reference to legitimate concerns, and 2, proportional, in the sense that it's necessary and suitable. And in practice, most controversial cases, most court cases on the exact border between European law and national law, they are decided on this proportionality test or the justification test. So this is the main legal test. And it determines what is under the European Convention called the national margin of appreciation, what is left for the national government and parliament. On justification, one can infringe European law if there is proper justification by reference to legitimate national concerns. And here you find under the convention specified which concerns, national concerns, can justify national restrictions. It's typically national public order, national health, morals, the rights of others, and etc. And you find the same in EU law. Here the scope is wider. In the EU law, almost all sensible national requirements, concerns, can in principle justify exemptions, except for purely economic and protectionist and discriminatory concerns. And this is subject to judicial review. So it will be for the courts, the national courts and the supranational courts, to decide, is the justification of the national parliament really legitimate or not? And under both legal regimes, they operate a kind of hypocrisy test. So even if the national parliament states that, well, we have these national restrictions in order to achieve this and that, the courts will go into that and see, is that really the reason why you have these national measures? Or is it really because you want to be protectionist or have other illegitimate? So this is subject to judicial review. And then there is, even if something is justified, it still has to be proportional. And that's the most important test in practice. And you find it in the convention, and you find it under EU law. Is the national measure proportional in the sense that it is necessary in order to achieve these legitimate justification concerns? Proportionality is at first sight a very easy concept. You have these two weight scales of justice and you weigh them against each other. It sounds very easy. Okay, it can be proportional, not proportional, you can go into that. But if you look closer on the principle of proportionality, you will find that it is, even from a legal point of view, an extremely complex principle. And it raises a huge number of questions. What kind of proportional? Proportional in proportion to what? What should be in that scale? What should be in that scale? And how to apply it. And in reality, this proportionality principle leaves enormous discretion to the people deciding, which will be the judges. So it leaves the final decision to the discretion of the judges. Is it proportional? Is it not proportional? It's a complex issue, but this is the standard. This is the legal standard for determining the balance between the European and the national level. I will give two short examples of this before we conclude the lecture. And both cases are from Norway. Both cases are quite recent, and both cases concern national Norwegian restrictions on advertising. Both cases relate to laws that were passed by the Norwegian Parliament and that were challenged under European law. One of the cases is on the prohibition against alcohol advertisement. We have such a prohibition in Norway. And the other is on the prohibition against political party advertising on television. And the first one was challenged under EU law through the EU agreement, and the second was challenged under the European Convention on Human Rights. But the cases are quite similar if you look at them in a broad perspective. First, there is the prohibition on alcohol advertising. Norway has the strictest rules on alcohol advertisement in Europe. The Swedes used to have almost as strict rules as Norway. All kind of advertisement for alcohol, be it on television, in the newspapers, in magazines, on the internet, they are prohibited under Norwegian law on alcohol. This was challenged. They had the same rule in Sweden. It was challenged under European law because prohibition on alcohol advertisement is, of course, also a prohibition on the free movement both of goods and services. Advertisement as a service and alcohol as a good, as something that can be traded. You sell less alcohol if you cannot advertise it. So it's a restriction on the free movement of alcohol, which is a restriction on the free movement of goods and services. And this came up first in Sweden in the late 1990s in the so-called Gourmet case. It was a Swedish magazine which printed, for the purpose of getting a court case, printed alcohol advertisement. And the case was sent from the Swedish National Court. It came up before the National Court in Sweden, and it was sent to the European Court of Justice in Luxembourg. And the European Court of Justice said that, prohibition against alcohol advertisement is a restriction, yes, but it can, in principle, be justified if it is proportional. And they left it for the national Swedish courts to determine exactly, concretely, in the given case, whether it was justified and proportional. So the case went back to Sweden, and the Swedes, which are very law-abiding, they took this very seriously, and the Swedish courts came to the conclusion that the Swedish prohibition was not proportionate under EU law. So they had to change the Swedish law. The day after the Swedish court judgment, there was a Norwegian magazine, a wine lover magazine called Vinforum, who printed, on purpose of course, an advertisement for wine in Norway, in order to get the case in Norway as well. So, and they were of course fined by the Norwegian authorities, and the case came up before the Norwegian national courts, and it was sent to the EFTA court, which is the small court under the EA agreement that we have also in Luxembourg for the EA agreement. And the EFTA court came to exactly the same conclusion as the European Court of Justice. They said that this prohibition is a restriction, but it can be justified if it is proportionate, and that is for the Norwegian courts to decide. So it went back to the Norwegian courts, and it went through 3 instances: the City Court, the Court of Appeal, and the Supreme Court. And the Norwegian government put up a lot more of a fight than the Swedish authorities. They really wanted to preserve this prohibition on alcohol advertisement, and they succeeded. They managed to argue the case and to convince the Norwegian Supreme Court that this is indeed proportionate. It is justified by reference to public health, and it is proportionate in the sense that it is suitable and necessary in order to protect public health. And the Swedes were wrong. That was part of the argument. They didn't understand it. So you can see this is a bit unpredictable. The same rule in Sweden, it led to one conclusion. In Norway, it was argued a bit harder. The Norwegian Supreme Court, using their discretion under the proportionality test, came to the opposite conclusion. And we still have a total ban, I'm sorry to say, a total ban on alcohol advertisement in Norway. So that was one example on the European Convention, on EU law. And then the second case was on political advertisement on television. We have a total ban on this in Norway as well. It is not allowed for political parties to place advertisement on television. They can place it in the newspapers, on the internet, but not on television. And again, this has been a rule in Norway for many, many years. It has been politically debated by Parliament on several occasions, and it is politically controversial. Parties have different opinions, but the majority in Parliament so far have wanted to keep this prohibition on political advertisement because we do not want to have this commercial influence into politics. And everybody points to the United States and how the attack ads in the United States are used, and we do not want this in Norway. So there's a total prohibition on political advertisement on television. And this was challenged. It was challenged under the European Convention on Human Rights as an infringement of freedom of expression under Article 10. And the case, it was a test case again. It came from a very, very small political party on the west coast of Norway, a party for pensioners, for retired people, on the west coast of Norway. And this party was so small that it was never invited to political debates on television. So it had absolutely no access to television as a medium for putting its message forward. And because of this, they made a test case. Of course, they were financially backed by a TV channel, private TV channel, who wanted to start having this source of income. And they sent a small advertisement, and they were fined, and they took the case to the courts, to the Norwegian courts. And the courts referred the case, the courts decided the case. It went through City Court, Court of Appeal, Supreme Court, and the Norwegian Supreme Court said that this is not an infringement of Article 10 of the European Convention. It is a restriction, but it is legitimate, it is justified, and it is proportional. It's necessary in a democratic society. But the case did not stop there, because after they had lost in the Supreme Court, the party took the case to the court in Strasbourg. And the court in Strasbourg came to the opposite conclusion. They came to the conclusion that this was an infringement of the European Convention. And to that extent, Norway it was laid down that Norway had infringed the European Convention on Human Rights. And this led to a debate in Norway. And the story, again, did not end here. Most people, when the judgment came from Strasbourg, most people thought that, oh, we have to abandon this national prohibition on political advertisement. But then the government lawyers looked into the case, and they said that, well, the reason why the court in Strasbourg said that this was an infringement of Article 10 was not the total ban in itself. It was not a general ban against political advertisement. It was only the specific circumstances of the case, namely that this very small political party had no other way of getting its message on television than through commercial advertisements. And that was the infringement, not the total ban. And again, you can see this is the application of the principle of proportionality. It was not the general proportionality. It was the proportionality for this very small political party. And that was the infringement. And that meant that, as concerns the big political parties, who are invited to radio and television almost every day, there is no infringement. And the Norwegian government came to the conclusion, which is debatable and controversial, but they came to the conclusion that we can fulfill this judgment by not taking away the prohibition, but taking other measures in order to allow for small parties to get on television. Not through advertisement, but through other measures. And they tried to do so. And whether they really did it or not is debatable. But the main point is they kept the prohibition. So you can see these two cases. There is European law, there is a challenge, but the outcome of both of these cases was that the national restrictions were kept after very long, extensive, very costly judicial processes. And this illustrates the main point that even under this European new federal legal order, there is still a huge scope for national measures, if you know the system. There's a room of maneuver, there's a margin of appreciation, but you have to work inside the system and you have to know how it works. And it's very complicated and it's not always predictable. We are coming now soon to the conclusion of the lecture. The Europeanization of law. In Norway, we do not really, I would say, most people, the great majority, do not really know or understand that there's been a revolution. I studied law 20 years ago, and I studied under a national legal system. My students today, I'm a professor of law here, my students today, they study law under a federal legal system. And this is something that most Norwegians are not aware of. And it's not the future, it is already here. As citizens of a European state, we are also today European citizens in a legal sense. A very large and growing part of our individual rights and obligations derive not from national law, but from European common federal law. And it's not decided at the national level, it is decided at the European level, and it's developed not at the national level, but it's developed at the European level through political processes, but to a great extent through judicial processes. This has so far, as I said, been a one-way process. There's been no major setbacks in the last 20 years at least, and even before that, and it's still going on. The process is still going on one way. It's not to say that it will go on forever. There are increased criticism on this. You might see signs that this, if you look at it as a pendulum, that this pendulum has reached the top and might start to swing back a little bit. There is in the EU increased calls for clarification of competences, application of the principle of subsidiarity, application of the principle of proportionality. There is even under the European Convention increased criticism of this convention. Up until now, the convention has been almost holy. There's been very little criticism. It's almost illegitimate to criticize. How can you criticize a convention on human rights? Are you against human rights? Of course, we're not against human rights. But it has developed so far that now for the first time in Norway, but also on the European scene, you are seeing criticism of this system, that it has gone too far, that it has gone beyond the core fundamental rights and into details which should be left to politics and not to the treaty system. There might be some, if not reversion, then it might at least stop up, probably in the future. But it will not go back. The Europeanization of law is not something in the foreseeable future that will be reversed. So as European citizens, we live in what the Chinese call interesting times, times of great conflict and controversy, but interesting times. And we have to live with this increased tension between the supranational level and the national level. But that is not in itself a problem. Any citizen or lawyer from the United States or Germany will tell us that it's really quite interesting. And it gives a lot of questions for lawyers to ponder over the years. What is the competence division between the European level and the national level? Thank you.